Hello, and welcome to Law Deals, the podcast for legal professionals navigating the business of law, law firm partnerships, and law firm ownership transitions. I'm Ed Alexander, and today we're diving into private equity ownership of law firms and what you should do about it. For this key topic, I'm joined by my friend Jonathan Hawkins, the founder and managing partner of Law Firm GC, an Atlanta-based law firm that is focused on representing other law firms. So this episode is going to be a little bit different than our normal routine because this is going to be the first in a multi-part episode, and really we're discussing how private equity invests into law firms and what the structures are. So Jonathan, welcome to the Law Deals podcast.
Thanks for having me, Ed. This is going to be fun. I mean, this is where we're headed. People say it's coming. I say it's here. So.
It's already here. That's exactly right. Right. So let's kind of talk about the two models for private equity investment in law firms. I call them the direct ownership and the indirect ownership model, right? And so obviously direct is non-lawyer owners of law firm equity. So that would be a private equity group, or it could really be any person who isn't a lawyer. And then indirect ownership is going to be a completely different structure where we've stripped out the legal practice component and we hold on to everything else but it. So let's go deep into the background first. So what are the rules that prohibit a non-lawyer from owning an interest in a law firm?
Well, this goes way back, way back. Pretty much across the country, non-lawyers could not own law firms at all. I guess, I don't know how far back it happened, but DC sort of opened the door a long time ago. And they have some restrictions on that. But that was mainly, in my opinion, to allow the lobbyists sort of join forces with the law firm. So again, I don't have the requirements in front of me, but basically it has to be an individual. They have to actually work at the firm and all this stuff. So it's not really an outside sort of silent owner. They're actually participating in the firm. And that's been there for, as long as I can remember. And then of course, there have been some cracks, and they call them the sandbox out in Utah, and some other places have sort of experimented with some version of it. And then, of course, everybody really knows now Arizona just kicked the door down and said, we're letting it, anybody can own it. And so that's sort of where we are now. I know there have been other states that have looked at it and backed off, and, there's still states, quote, looking at it. We'll see. Maybe 2-3 years ago, I think California was looking at it pretty heavy. And then the ABA came out and just really slammed the door on it. So some states stepped back, but I think they're looking at it again. So really, it's state by state. So we'll see. I don't know. What have you seen?
Yeah. So I mean, ultimately, right, the Florida Bar Board of Governors unanimously voted to turn it down a couple of years back, right? And really, what that amounts to is a change. It requires a change to the ethical rules, right? So there's ABA Model Rule 5.4, and really it contains two components. The first is that lawyers aren't allowed to fee share with non-lawyers. And then the second is that we aren't allowed to partner with non-lawyers where the subject of the partnership is practicing law. Now, at least in Florida, I think we've got some special rules, right, regarding that. But I think that's prevalent throughout most of the states. And in Florida, it's Florida Bar Rule 4-5.4 that gets us there, and it's A and C of that rule. So in Georgia, you have the same setup there, right?
Yes. I don't have the rule in front of me, but it's based on the same ABA model rule, and it's yes. Non-lawyers cannot own law firms in Georgia,
right,
at the moment.
Yeah, and at least in Florida, non-Florida bar attorneys even cannot own law firms in Florida, right? There is an exception, and that exception is for what they call the interstate law firms. So this would be those large law firms, maybe based in New York, LA, Chicago, and they want to open offices in Miami or Orlando, that kind of thing. And there's an ethics opinion out there in the Florida bar that requires, if they do that, that requires them to have a Florida bar attorney as an actual equity owner of the firm. And for that attorney, or at least one of the partners, to actually manage the Florida office. So there's a little way around it, but no matter what, they have to be admitted to a bar in the United States, right?
Well, I was going to say, yes, I have encountered that because I've had clients that have wanted to explore opening a Florida office. So I've had to look at that. And, Florida is very protectionist of its lawyers in all sorts of ways. And that's one of the ways that I've sort of seen a lot, which I don't know every state in the union what the rule is, but I can tell you that's not the rule in Georgia.
And I think it's not the rule in many states, right? Many states, because many states also offer reciprocity, and we offer reciprocity to no one. So,
Yes.
We've got that there. So, all right. So let's talk a little bit about the partial exception for local counsel, right? So, tell me that structure, how that works when it comes to local counsel.
You mean an out-of-state firm working with a local counsel?
Right.
Yeah, I mean, most states allow, they have sort of the multi-jurisdictional practice rules, and they're sort of the ways you can actually practice in a jurisdiction. So let's just say if it's litigation, that's the easiest. You get a local counsel, and then if there's going to be a lawsuit that you want an out-of-state counsel in, then you get pro hoc vice in. So that's sort of the easy thing. And I'll tell you, back to Florida, in that instance, I remember, when I first started, I did a lot of Michelin tire defense work, and they always seemed to file in Miami. It must be a really good jurisdiction the plaintiffs did. And so Florida allowed an out-of-state attorney to pro hoc in, but they limited it at like 3 cases a year. I don't know what it is now. So in our office, we would strategically have to have different people pro hocking in the cases at different times to make sure nobody burned all their uses.
Exceeded the limit. Yeah.
Again, that's another Florida, wall that they've put up. I'm not aware of any other state doing that. I don't know if it's still a rule, but yes, that's in the litigation context. Maybe you can. I mean, does Florida still require that? Do you know?
Yeah, absolutely. Still requires it. So we've got this set of rules here, right? And against this now, really, the whole episode was initiated by a Texas opinion that came out recently, 704, and it talked about this issue of direct ownership and the inroads that firms that have non-attorney owners are making into the various states. So you mentioned Arizona, right? So Arizona really created that alternative business structure, right? And it has to be approved by the Supreme Court and has to have certain things, annual reports and things of this nature. But it's really not that much of a hindrance to private equity coming into the firm, right? Ultimately, right, the practice there, now you've got to have an attorney who's managing the practice, who is the managing attorney of the practice, and they have to be structured. So what we've seen now is that what'll happen is private equity will create the Arizona firm, and then the Arizona firm will now reach out and try to acquire firms in other states, right? And that's where this Texas opinion came from. And essentially that Texas opinion looked through the firm. So it didn't stop at that firm, but basically said, hey, if there's a non-equity owner in the chain, then a Texas attorney cannot make a partnership with that firm for the practice of law. So they're really enforcing that rule 5.4 and keeping it intact. So what have you seen on these various transactions relating to direct ownership?
So I have not seen any direct ownership of non-lawyer money. I'll just put it that way.
Right.
Yet, direct ownership in a being very clear here, in a law firm versus what we'll get to a little later. And so, I think pretty much now, are people doing it? Maybe quietly. I don't know. Mm-hmm. We'll see. Another interesting issue that maybe you're going to bring up, but there's the ownership piece. But what if you have a Arizona ABS firm that co-counsels with a law firm in Florida.
Right.
So there, maybe you're going to get to that in a minute, but so it's not a direct ownership, but it's more of a co-counsel relationship.
Right. So then now we're looking at, and we'll go down this little path for a second here, but now in that case, we're looking at, are we now sharing fees with non-lawyers, right? So what then, so we do a co-counsel, they're entitled to their fee. What if they're billing the client directly that fee, and the client's paying the Arizona firm, and then the client separately pays the Florida firm? So there's no, or whatever firm, Texas firm, Georgia firm, so that there is no direct sharing from the firm to from the Florida firm to the firm in Arizona. Does that violate the rules? I think that at the end of the day, if the client is paying the fee to the Florida law firm, and then the Florida law firm is paying a portion of that fee to the Arizona law firm, then there is a violation of the Florida rule against sharing fees. Would you agree?
I think so, and I think Florida would agree too.
Yeah.
You know, it's interesting though. There's one point. I haven't looked at this in a while, but I think, before Arizona came on the scene, it was just DC, right? I feel like I remember seeing some opinions that basically said, as long as it complied with the local rule about how it's formed, it would be okay to work together and share fees. That's my recollection. Again, no legal advice on this.
100%. No legal advice, just discussion. Yeah, no, I think you're right. But I think that when I looked at Texas Opinion 704, and I would encourage everybody who's listening to go take a look at it, it specifically talked about the partnership element and really kind of that entire rule. So I would think that the fee sharing component would be violated in that case. So if there is a local counsel arrangement, then it seems to me you've got to set it up where the client pays the Arizona firm and then the client pays your firm. Question what amount of due diligence the lawyer now has to do if they're working with an Arizona firm, or a firm really in any jurisdiction that allows non-attorney ownership. So some open issues there.
Yeah. And I mean, due diligence will only take you so far.
Right. And so on some level, would you potentially be in violation? Now, let's just go back to the direct ownership piece, right? Because the structure that I've seen is that the Arizona firm would acquire a firm. And to my understanding, I've heard from people in the law firm community that this has actually happened in Florida already, and that the Arizona firm acquired a personal injury firm and then is operating. So that means that the attorney who owned that firm, or attorneys who owned that firm, are now in partnership with the Arizona firm, and the requirement that they manage that office and that they be equity holders now puts them in harm's way, I think, of the rule, that 5.4. So would you agree?
Yeah. Something I've always thought about, and this is even before Arizona opened it. What if you have a private equity fund who all the partners or limited partners or funders or owners, whatever, are lawyers? So it's not a law firm, but it is 100% owned by lawyers. And this non-law firm owner, is the private equity owner in an ABS.
That's a very interesting arrangement, right? I mean, at the end of the day, then, yeah, you're in partnership with lawyers. It would start to look like an interstate law firm structure, right? And realistically, now we have lawyers, I have clients who own multiple firms, and that's permitted, right? As long as we've got different partnerships and we're not doing anything that would be considered deceptive or unfair, right? And so there are opinions out there that describe that deceptive and unfair arrangement, and those typically revolve around personal injury, where a personal injury firm now wants to get into the insurance defense game or vice versa. And then the bar has been very clear that those are deceptive and unfair, and you can't do that. But I can have a firm that operates in Atlanta, and I have an Atlanta partner in that firm, and a firm that operates in Miami, and then a different partner in that firm. Those are permitted under the Florida rules. Would they be permitted in Georgia?
Yes, similar.
Have you seen those structures? Do you have any thoughts on those?
Yes, I've seen them. They're around. I do have some thoughts. I mean, I have mixed feelings. On the one hand, so let's say I'm a personal injury, car wreck lawyer, but I want to have a workers' comp firm. What if I want to divide and basically have two firms? So instead of having two verticals under the same firm, I wanted to sort of separate them out for whatever reason. But I own both of them solely. That is not allowed under the Georgia rules. Now, there's a very old ethics opinion in Georgia that says you cannot do that. Now, if you have different owners, you can, but if it's basically the same owners, you can't. That opinion was based on the old model code,
right?
Not the rules of profession, not the newer one. So is it still valid or not? Because I think whatever it was based on in the old code did not come over, but it's still there on the books. And I got to admit, I think that's kind of silly. I mean, because I can create a sort of a brand and maybe even a different website for the workers' comp and the car wreck cases. Why can't I just spin them out into two entities for business reasons? It doesn't make sense to me. I think in that regard, the rules are behind.
Yeah, it doesn't make sense. I think there are other rules that protect clients in that case, right? So if you're referring your workers' comp clients over to the personal injury side, the rules in effect about ancillary business, at least in Florida, we have to have a disclosure. We have to have the client sign off. We have to have certain requirements in there about the ancillary business relationship. So if you're doing that, it would seem to me like the client is fully informed. The client understands they can go wherever they want for it, right? But now what you're doing is really setting up that structure. I agree that is an antiquated rule. And the way we've been getting around it is we bring somebody into each of those firms. It's a minority partnership interest. It has to be a real partnership interest in Florida because there is no such thing as non-equity partner in Florida. But we deal with it that way. And so the person who's managing that office then becomes a partner in that deal. And setting up that partnership agreement, which I know you have a lot of experience with, is essential to make sure that that's going to work. But you're giving up a small percentage of your profits.
And it adds just a whole other layer of fiduciary duties and I mean all sorts of stuff. But I don't know. There are all these rules, and part of our jobs, you and me, Ed, is to stay within the rules, but figure out a way to, and we'll get to some of this later, but create structures that get us sort of where we want to get, but within the rules.
But within the rules, right? That's always the key issue here. So, okay. So ultimately, I think just to wrap up on the direct ownership piece, right? The rules really prohibit, at least in everywhere except the states we've kind of talked about, DC, we've got some in Utah, there's some structure in Utah. It's not really quite as open as other states. We've got Arizona, which is very much open, and then we've got Washington State, which is toying with some things as well, right? I don't know that there's any other states that are really out there with this. They may be thinking about it, but they're not out there with it, right?
I think that's right. And one other thing maybe I'll just throw out there before we move on, and that's in every context. I mean, when you get to the point where through whatever iteration that you're owning multiple law firms, there is a conflict question that may get pulled front and center. I mean, it's sort of like, of counsel relationships. In theory, you can be an of counsel in an unlimited number of firms, but the restraint is really a sort of a conflicts question. You couldn't be an of counsel with every firm in town because you'd be on both sides of the V. And so the question is, if whether it's a group of lawyers or a lawyer or a private equity fund or whatever, as you own more and more law firms, eventually there's going to be a conflict potential issue. And how do you deal with that? I don't know the answer, but it could be pretty complicated, I would think.
Yeah, so I think that's where some measure of jurisdictional difference and practice similarity would be helpful, right? And ultimately, that's where you would have the problem in the example of we represent insurance defense, or we're in insurance defense and we're in plaintiff's personal injury. It's only a matter of time before you find yourself in a conflict situation, right? And you'd be surprised. And I think it's important for lawyers listening to the episode to recognize that as you're bringing people in a contract capacity or in an of counsel capacity, you must have that agreement that is dealing with this conflict issue and making sure there's some form of disclosure so that you don't wake up one day to a motion to disqualify because your contract attorney was on the wrong side with another firm and also with your firm too.
But yes, 100%. I have some, and I've had some big personal injury clients in the past where, they sign up an entire car, let's just say, and a driver and 2 passengers. Sort of a classic. There's a couple of classic conflict situations that could arise. One, there's some element of fault on the driver in that car, shared fault between that driver and the driver in the other car. So then the passengers are then sort of in a conflict situation because they got claims against the driver that they were with. And so you can't represent all of them. So that's one classic. So you sign them all up and they're all plaintiffs, but you can't represent them.
Right.
Some firms do, but you're not supposed to. The other classic situation maybe in that is, let's say there's no fault or issue of fault with the driver, but there's limited insurance funds, and the injuries are much larger than available funds. So then it's like, who gets what?
Yeah.
And so, that's even within one firm. You start stacking other PI firms all around it. I can see a situation where you represent everybody in the wreck. There's a
right.
4 cars in a wreck.
Yeah.
You represent all of them.
Right.
Yeah.
And so it's interesting because this conflict issue really relates to, okay, what level of involvement are you having? Are you a passive investor? Are you not a passive investor, right? And then how does that conflict come down? So from an ownership perspective, though you have multiple firms, as a practical matter, it could be limited. We got off a little bit on a tangent around contractors and of counsel, but at the end of the day, relating this back to the ownership arrangement, even if you had that private equity firm that's full of lawyers, and that private equity firm is now owning multiple law firms in a state or in multiple states, what do you have to do then in the ownership arrangements to deal with those conflict issues? And how do the owners not participate in any of the operations to avoid that, but are merely passive investors? And my experience with investment in small business is that the investors do not want to be passive. They want to know what's going on and help manage. So good. Okay. So real quick, let's wrap on this direct ownership piece. And, do we agree that it's likely that most of the states are going to look disfavorably on a Arizona firm coming in and owning a piece of a Florida, Georgia, whatever law firm where the Arizona firm has non-lawyer owners?
I would agree.
Okay. So in that case, I would encourage, at least in Florida, we have the Florida Bar Ethics Hotline, and I would encourage any lawyer looking at a deal like that to most certainly call the Florida Bar Ethics Hotline before doing anything. Okay. In our next episode, we're going to get into the other model, which is indirect ownership. And we're going to kind of talk about what those structures look like and how they can run afoul of the ethical rules. And so get ready for the next episode. Thanks for listening, and we'll talk to you soon.